Good evening. This is John Milburn. This is Laws 11057, Week 10, Introduction to Law. And tonight we're talking about legal research, but a whole lot of other things as well. I've had a request to explain something about Turnitin. It's a program that's used by the university to effectively check on plagiarism. What it means is that in reality, when your work is presented to me, as it filters through, I'm able to detect what percentage, if at all, of your work matches work that's on the internet or work that's been provided by other students. So it's a very effective tool, and it provides us with a lot of opportunities to see where your work did come from. So that's why it's very important, of course, that you reference your material. So if you have any questions, specific questions about Turnitin, please let me know. All right, tonight we're going to give a few exam hints. Before I do, I just want to give a refresher on verbal communication and do that in the context of mediation. So many of you would be aware that I do take alternative dispute resolution as well. It might be a course that's of interest to you down the track. So in mediation, we're dealing with communication in a very real sense, where in the middle of two parties that are probably showing a lot of anxiety, a lot of emotion, they've got an issue that needs to be resolved, and part of your job is to assist those parties in coming to a sensible resolution if possible. There are a couple of important points in mediation. The first is that as a mediator, you don't take over the dispute. You must allow the parties to own the dispute and continue to own the dispute. You must make a connection with the parties, and one of the important ways that you do that is by maintaining eye contact and the use of positive body language. Simple things like making sure that you remain connected with the client or the participant in an equal way can make a big difference to the ultimate outcome. Your body language, whether you actively sit forward and use hand gestures, open movements, are also very important as well. To quote from Professor Ashman of QCAT, the participants must feel as though you are their new best friend. So the art of mediation requires you to be dynamic and lively for the most part. Now that doesn't mean quick or loud or eccentric, but it means that you are actively working hard and seem to be working hard to assist the parties. So it is a process where you are confident, you are able to communicate in a clear way, but in a connected way. Part of that means that you maintain eye contact, and you've got to learn the art of being able to write material selectively, carefully, but not to lose the connection with the parties. So during the mediation session, you're trying to coach the parties, you're trying to reality test with them, you're providing them with encouragement all the way through. And your role is to keep the parties focused on the end result, encourage them to work their way through difficulties. So all of this requires a lot of the skills that we're trying to instill in you in terms of verbal communication. That said, as mentioned before, you don't take over the dispute. You must allow the parties to keep ownership of their dispute. Tonight we'll be talking about the first steps in litigation, and much of what we'll be talking about involves you as the lawyer taking ownership of the dispute on behalf of your clients, keeping your clients at a distance, representing yourself as the front person and allowing the clients to stay in the background. The session I'm doing now in mediation reverses that situation, where as the mediator, you want the clients, the participants to come forward, you want them to interact to some degree initially with you, but for the most part with each other. So what you're trying to do is turn around a situation where they don't want to talk, they don't want to come to a situation where they're engaging with each other, and you set the rules, the parameters to allow them to do that. So that's the contrast between mediation versus litigation. So some of the techniques we use in mediation, we ask open, clarifying questions. We try to avoid cross-examination or closed questions. It's not an interrogation. It's an opportunity for the parties to start to have some meaningful dialogue with each other. And you must be careful to ensure that you don't become like a commission agent where you're taking offers from one party to the other. That's not what mediation's all about. It's encouraging the parties to extend offers to each other, and you remain in control of the process, but you allow them to deal with their own negotiations. A couple of other things, and this goes generally, you try to avoid series of perceived bias, and you concentrate on your body language, maintain eye contact, and be lively. To quote from Judge Kingham, formerly Deputy President of QCAT, be light on your feet. And ultimately, think about why you're there, and that is to help the parties. So that's a brief introduction into mediation, but it's also relevant in the context of your verbal communication skills. All right, exam tip. There will be something on separation of powers, but with a twist. It might be worthwhile having a look at a paper that I wrote on ADR and environmental law. I'll just go to gallery view briefly. Has anyone had a look at that paper? I put it at the bottom of Moodle. Just a quick thumbs up if you've had a look at it. No? Yes? A couple have? Yep. All right, so just have a look at that and perhaps think about the decision of BHP and Isdale, which was 2015 QSC 107, and think about whether that might have some impact on the question of separation of powers. Also, think about a situation where, and this is a separate issue now, think about a situation where you might be put on the spot as a first-year lawyer by a client or perhaps by a partner of the firm that you're working for. And think about what you might do in a remedial sense if you do have to provide advice in relation to a triage situation for criminal law perhaps, or perhaps the first steps in litigation in a civil matter, or perhaps some ethical issues. Might be a combination of all of those things. All right, that's probably all the tips for tonight. Not very many, but hopefully they're helpful to you. Any questions from what I've said tonight so far? All right. Let's talk about research skills. I mentioned some things that I'd like you to consider leading into tonight's session. So the first is your client wants to pursue a debt for $5,000. Okay, so I'm going to invite you to put in some comments on the chat facility, or you can come in live if you want. And your client comes to you and says, I want to pursue a debt for $5,000. Fine. What are some of the questions you need to ask yourself? So can you fire away? $5,000 debt. I'd like you to help. Tell me some of the things that you'll ask yourself, maybe your client. All right, so how did the debt arise? Is there a contract? Very good. So you're looking for the evidence. Who was the debt with? So what we're seeing already is who, how, what, why, where, when. These are wonderful questions, all those W questions. So when did it occur? Excellent. What state did it happen? That's a really good response. Who was the debt with? And be careful, it may not be who you think it is. It might be a company, it might be a trust. Is there a contract? Great. And a contract may not have a heading that says contract. It may not even be in writing. The contract might be verbal, might be partly in writing, partly verbal. How did the debt arise? Excellent. That will have a bearing on things. So lots of, were you the only one on the contract? Was there consideration? Excellent questions. I love all these questions that start with W. So just an idea, in practice, you might have a list of questions that you will keep with you for your career and add to it, and lots of questions about who, where, when, why, etc. So a lot of the things that you're doing tonight, take that into your examination as well. Might be useful. All right, so I like all those questions. Now, can tell me What is the relevance of when did it occur? Far away. You've asked the question, when did it occur? What's that got to do with it? Limitations. Love it. Thank you. Statute of limitations. So when legislation was current. I like that as well. So that's good. So you need to know something about the statute of limitations. Yes? So try and have something along those lines. Has anyone come across any ready reckoners for limitations? Might be useful. We'll see what we can do. All right. So the question of when did it occur? What's the relevance of what state did this happen? That was Tiffany, thank you. What's that got to do with anything? The court, yes. What court do we go to? Thank you, Diane. Jurisdictions, different jurisdictions, state to state legislation changes, may not be the same law. Okay, so you need to consider that as well. What about the question of who the debt is with? What's that got to do with anything? Why should we ask that question? Who is the debt with? I gave some hints before briefly. Is it a minor? Oh, I like that one. Is it family or private, or is it commercial? Yes. Start the litigation with a corporation or person that's appropriate. It might be a company. It might be a relation. It might be an individual. It could be a social or commercial contract. It could be a family, company. Is there an issue about capacity to contract? I like that as well. It might be a trust. It might be a partnership. It might be an employee who has made a contract on behalf of an employer. So there may be some vicarious liability there as well. I don't know how quick you are at writing, but they're all really good points. And these are the things that you need to have some notes prepared so that it will prompt you when you come to think about these questions. And I'm not just talking about the exam, I'm talking generally as well. What happens if in your first year of law you issue perfect pleadings, $5,000, you do everything right, but you forget that it's statute barred, or you go to the wrong court, or you sue the wrong person? Again, how are you going to feel after the event? Work your way backwards. You're not going to feel too good about it. And you're going to think to yourself, oh, that's so obvious when I look at it in hindsight. I wish I had taken some precautions from the start. Well, here, tonight, this is your chance to take your precautions. Start thinking about those issues. Now, where do you start to look for some guidance to give you some really good tips on some of the traps that might be relevant? There's textbooks and there's legislation. Are there any websites that immediately come to mind that might give you some good tips in relation to issues to do with problem? Solicitors' conduct rules, court websites, yes, I agree with all that. Any other websites? QCAT, yep, that could be useful. All right, how about the Queensland Law Society? Courts? Has anyone heard of Lexon, L-E-X-O-N? That's the Law Society's, the Legal Practitioners Indemnity. There might be some good information on there as well. All right, so we've decided that in relation to this debt, we've got a whole lot of questions we want to ask, and we need to determine the cause of action. Is it a breach of contract? Is it something else? What are the main pieces of legislation that come to mind when considering chasing a debt? Are there any pieces of legislation that you should think about? Statute of limitations, yes. Consumer Act, that's the one I was after. What's the important consumer legislation for Queensland? Sorry, let's assume this debt is in Queensland. It's a Queensland debt. What consumer legislation do we look at? I said it's in Queensland, and that could mean that we're looking at Queensland legislation, or it could mean that we're looking at other legislation as well. Australian consumer law, thank you. That's the one I was after. All right, so the point is that you've got to bear in mind that you may need to research both Queensland legislation and Commonwealth legislation. All right, so what's the normal way to start pursuing a debt? What do we normally do? Perhaps even before we go to court. What's maybe one of the first steps that you might think about advising? A demand letter, thank you. What if the client says, oh, forget the demand letter, just go straight to court? Is there a risk negotiation? I like that. Yep. But what if the client says, no, don't go, no demand letter, straight to court, sick of them? Is there something that could come back to bite the client by failing to send a letter of demand? The court may say you haven't followed procedure. The client haven't given the client an opportunity to respond. I like those answers because there is a risk. It's a good risk, but there is a risk that the respondent might simply pay straight away and say, here's the $5,000, but you can forget about the $1,000 in legal fees because I would have paid if you'd sent me a letter of demand, and it would have saved all those legal fees for drawing the procedures. So if you went to court, the court is likely to say, yeah, I agree with that. You're not getting your costs. So then there is the issue of the costs, and you need to advise the client about that. Are the costs equal to, less or more than the amount trying to be recovered? So costs issues are relevant as well. So there might be some issues of dealing with that response from the debtor. So you need to consider some alternatives, and you may have some concerns about bankruptcy. So it's all very well to issue the proceedings, do a wonderful job, get an order for the money, but then ultimately have no opportunity to recover the money in a real sense. Do you think your client might be upset if that occurs? The client's just paid you $5,000 to secure a judgment for $5,000 against someone who then immediately goes into bankruptcy. What's your client going to say about that? You didn't warn me that I may not recover. So incompetence. So part of what you've got to do here is think about the worst case scenarios at every step. Think about the risks associated with pursuing the matter, and make sure, of course, that you provide appropriate advice to the client about some of these risks. One of the risks, of course, might be that you lose the case. And that needs to be considered from a cost perspective as well. Now, we want to issue proceedings for $5,000. Where do we go? Which court, which tribunal? How do we proceed? Lower court, yes. But what is the lower court? QCAT, magistrates, yes. Small claims, magistrates. We don't have small claims as such anymore. QCAT has a division called the Minor Civil Disputes Division, which is the old small claims tribunal. Okay, so the client says, all right, well, do I go to the magistrate's court or do I go to QCAT to recover this $5,000? What do we say about that? QCAT's cheaper, yes. QCAT, all right, so most people say QCAT. Is there any point in going to the magistrate's court? What are some of the advantages of going to the magistrate's court as opposed to QCAT? Courts will have the opportunity to appeal. Yeah, there are appeal rights in QCAT as well. One thing that was in the papers just last Sunday is QCAT has no ability to enforce its own orders. So if you get a judgment in QCAT, you then have to go to the magistrate's court and take out that judgment. And the clients might say, well, why didn't we just go in the magistrate's court in the first place? If I'd known that I have to take a judgment from QCAT and then convert it to a magistrate's court anyway. So there's that issue as well. And sometimes you'll find that QCAT won't order costs, whereas the client may specifically say, I want you to claim the debt and I want you to claim some of your costs, if not all of them, against the other side. So that's another reason why you may want to go to the magistrate's court instead of to the tribunal. Now, there may be some preliminary issues before you go and launch the action. Are there some preliminary procedural legal rules that need to be considered? Are there some preliminary things that could that are required to be done, which if not done, may mean that ultimately your matter fails. So can you think about that? Are there some preliminary steps which need to be done? Lodge an affidavit of service, yes, but even before that, even before you issue the proceedings, is it possible that there are some steps that need to be done as a preliminary before you can even issue proceedings? All right, so what if in the contract it says if there is a dispute, the matter must be referred to mediation? So Scott and Avery clause, as we call it. Maybe there's a preliminary in the contract. Yep, a dispute resolution clause. Thank you, Scott. So maybe that's an issue. Maybe there's some issues to do with the profession or other requirements that need to be fulfilled. So, for example, for a lawyer to sue for money, perhaps an itemised bill of costs needs to be delivered before you issue the proceedings. Okay, so maybe the provisions are subject to the National Consumer Credit Protection Act. So there may be some statutory requirements which require, requirements which must be fulfilled, or perhaps there are some contractual terms that you need to consider before you proceed to litigate. All right, so now let's start to draw the proceedings. In the court system, it would either be a statement of claim or an application, probably. Then there's consider the matter of serving the proceedings. What if the person that you're suing lives overseas or interstate, or maybe is hard to find? Are there some things that you need to advise your client in relation to those things? You may need a subpoena. Thank you, Diane. Are there some other issues that need to be considered from the outset? And this is all about thinking about the things that might go wrong in the process, which you are required to advise the client of before you start the process. Need to check whether the contract was formed, yes. You may need to advise the client of the risk of issuing the proceedings, paying all the money, and then not being able to find the defendant, in which case you would need to maybe obtain an interlocutory order. Thank you, Diane. Maybe you need to get a process server. Yes, if it's interstate, you'll need to check what court to commence with, or you may need to comply with the Service and Execution of Process Act. So there are a few procedures there that you need to consider. All right, you may need to consider a thing called substituted service. In other words, if you just can't find this person, maybe you need to obtain an order where you can serve it on somebody else in the knowledge or the expectation that that person will be able to pass on the information. So an application for substituted service. All right, so let's say you have sued, you've done all the right things, the respondent has put in a defence and maybe a counterclaim. So what if you've got a counterclaim in relation to your original matter? So what you may need to consider doing is putting in a response, because if you don't put in a response to the counterclaim, then maybe your client will suffer a judgment by default in the reverse situation by not responding to that counterclaim. Maybe at that stage you need to start to think about costs and making a formal offer. You see, if you make a formal offer, then the other side may have to pay your costs if the end result is favourable to you, at least as good as or better than the offer that was made. Maybe at that stage you need to think about court or tribunal annexed ADR, mediation, we've talked about that tonight, or conciliation conferences. So maybe at the start, when you're taking instructions from the client, you need to raise the issue of mediation or conciliation, either from the outset or to flag that this may happen down the track. All right, so finalising the matter, if the service is affected on the other side and the service, and there's no response, there's no defence, then you may be in a position where you can apply for a judgment by default. Now, I think we talked about that judgment in default in reverse, where your client had suffered a judgment by default and your instructions were to make an application to set aside that judgment so that you could file a defence. I think we talked about that a few weeks ago. All right, so you might want to talk to your client about the possibility of filing a judgment by default in the event of there being no filed material in response to your application. Or you may have to start talking to your client about the costs associated with the hearing. And your client may wish to have you deal with this at the start, because you don't want to have a situation where you're 3/4 of the way down the litigation path, you've done all the right things, everything's perfect, but then when you come to say to the client, all right, the next step is the hearing and it's going to cost you $8,000, you don't want a situation where the client says to you, oh man, I wish you'd told me that at the start. If you'd told me that at the start, there is no way I would have issued these proceedings. Oh, this is just a waste of time. You can forget your bill. I'm not paying any of that. You understand the risks that we're running here? There's the reputational risk, and there's the risk to the firm of having an upset client, and issues to do with you for not fulfilling the expectation the client would reasonably have, that you would explain these things before embarking on the litigation process. All right, and then ultimately, as I said, enforcing the judgment, you may find that you do all the right things, go through the hearing, get the judgment, and then find that you can't actually recover any of the money. So there are a number of issues that you need to consider. And while it may seem simple, a client comes to you and says, look, I have a debt, it's $5,000, can you pursue that for me? You might think, oh yes, all you need to do is say, I'll get onto that straight away, I'll issue the proceedings, and we'll get you into court. But you've got to think about all the what ifs and the things that might go wrong. Okay, so before everything starts, you need to lay down all the costs. Thank you, Nick. I think that's the right procedure. I think you need to be able to take your client through and provide them with some good advice as to the likely costs, the likely time, talk about the risks associated with it as well, and think about the alternatives. So in the brainstorming exercises we've done, we've tried to think about different ways that we can attack this, and that needs to be considered in the context of that first advice as well. All right. Thank you very much for those contributions. They're very good. Need to go over all reasonable efforts to find the person and prove the service. Yep, thank you for that. Okay, so there might be some other issues as well. One of them is if it's a $5,000 debt and it relates to a tenancy issue, then there might be credit rating issues, which could be used to your advantage or disadvantage, depending on which side you're on. So Ticker, the tenancy database, may come into play as well. And you just need to be careful when you're pursuing a debt that you're not so vigorous that it's deemed to be harassment, which is what you can't do. All right, so are there any questions about anything that we've discussed tonight? It's going to be a short session tonight. Now, the reason I'm going through this is because I want you to think about the way in which you embark on your legal research in the context of some real-life examples. So in the text, it has some excellent progressions on how to research from step 1 all the way through. And really, I'm just asking that when you think about your legal research, when you think about giving advice, you go through and give all of those different scenarios to clients. All right, a couple of things. Problem 33 is me asking you to provide your fellow students with your top 3 tips in relation to the Australian Guide to Legal Citations. When I checked before we started this evening, I think there were about 5 or 6 responses. Thank you very much. I'd really like to see everyone have a go at that one, as we mentioned earlier. So problem 33. Part of the exercise in you coming up with your top tips is to think about how you are going to ensure that you comply with the Australian Guide to Legal Citations. Next one, assignment 3 is due on Thursday the 1st of October. So at this stage I've checked, I think there's only 2 students have put in their material. So we're not far away now. So please finalise your blogs and upload your assessment in the prescribed manner. Thank you very much, generally speaking, for putting your material in on time, as I expect it to be. Third thing, have you had your say? I think there's about 20 students have done that. Thank you very much for those that have done it. Those who haven't, please let us know. So Megan says, concerning Assessment 3, the overview says, comparing your experiences with those of your colleagues by reference to their reports on their blogs. Do you want that comparison in part 1? Yeah, I think, Megan, that might be a good question for you, crew, if you don't mind. And we'll see if we can get some general responses to that. So if you could post that in you, crew, I'd really appreciate it. Thank you. It'll give me a chance to consider the answer as well. All right, so next week we're going to do a little bit more in terms of legal research, and perhaps I'll talk a little bit more about the criminal law side of things as well, and of course legal ethics. Next week I want to have a look at redrafting gobbledygook. Remember right at the start I sort of gave you this scenario of a lot of talking for not many words. In reality, there will be one of those practical redrafting exercises in the exam, and we might have a look at the one that was last year and extract some points on how to go about that and develop some techniques. All right, well, I've done a lot of talking again tonight. Does anyone wish to ask any questions? I'll put you on gallery view. You can unmute your microphone if you want and ask a question, or you can just ask through the chat facility. Okay, so nothing at this stage? All right. Well, we might make it an early night tonight. Thank you very much for joining me, and all the best with your continued studies, and we'll see you next week, and we'll have a chat through you, crew. All the best. Bye.